Hello everyone and welcome. The Committee on Civil Aspects of International Child Abduction Bill 2016 has invited comments from the public and its various stakeholders. The bill, however, does not record the voices of the survivors of domestic violence. Today we have senior advocate Indra Jaisingh and lawyer Suranya Iyer discussing the issue, discussing the implications of India signing the Hague Convention on the civil aspects of international child abduction.
Oh, hello everyone. My name is Kiran Sanjeeva. I'm the father of a 5-year-old boy who is being illegally retained in India since 2014. So it's 3 years now he's been away from me. Um, there is this news click item that is there on the internet, which is anti-Hague, that is against India ratifying Hague Convention on child abduction. And also there is, what is troubling is there is a lot of misinformation regarding the actual situations. I am one of the fathers who is directly impacted by this. Miss Jaisingh and Miss Iyer are lawyers. They make money out of representing folks that are involved in such kind of cases. So I just want to make it clear what our vested interests are. My vested interest is my child's well-being and his development until he reaches the age of maturity where he can stand on his own. Whereas the vested interests of Miss Jaisingh and Miss Iyer are clearly their pockets. They seem to be concerned more about the parents than the children. So I just wanted to get that out of the way before we proceed further. The other thing I also want to point out is that circa 2006, Miss Jaisingh has gone on record saying that India should be ratifying the Hague and had recognized all the problems that arose out of such a situation. So it's really not clear why she is making a different stand today. Is it because the boom in the number of cases is creating a financial windfall for her? That is a question that everyone needs to be asking. Why are Miss Jaisingh and Miss Iyer so passionate about this? And in fact, they make all these conclusions without ever having contacted any of the left behind parents. So I just wanted to make these points clear before we proceed further.
Suranya Iyer works for the rights of Indian children taken away by Western U.S. child protection agencies. Last month, she submitted a report to the Ministry of External Affairs regarding children taken away from U.S. protection authorities, especially regarding young IT professionals, even though they have proven to be innocent. Do you agree with the term abduction, which is used with respect to parents?
This is the most objectionable part of this bill. I wonder if you recently heard the former Chief Justice, Justice Kehar, say at a meeting of lawyers which was held to felicitate him that Indian law doesn't consider a parent as an abductor. Now, the reason for this is very obvious, and the Law Commission also said the most objectionable part of the whole Hague Convention is the fact that it looks as a parent as an abductor. And the reason, of course, is very, very obvious. In fact, the reason is because the parents are the natural guardians of the child. So, a guardian cannot be ever considered an abductor. Okay, what is of relevance is the issue. So therefore, the bill is flawed, right for that reason, that it calls itself the civil aspects of International Child Abduction Bill.
Well, Ms. Jaising here has a point. The Hague Convention text does not really use the word abduction. Instead, uses the word wrongful removal and retention, which is fine, which is what it is. So, if there is a concern with the word abductor being used on a parent, then of course the name of the bill can be changed to not include that wording. However, there is still the problem of Ms. Jaising trying to make it appear as if just because they are parents, they cannot be abductors. That is like saying just because you are a parent, you cannot be a rapist or any other abusive behavior towards the children. Laws and society should evolve with time. What was considered acceptable at one time is not, and that is where we have these kind of discussions where we see are the current laws and the wordings appropriate for the times, and if not, we have to adapt and improve on those. That is why it's important to at least recognize that wrongful retention and removal is a crime, and it is child abuse, and whether there is the intention is there or not is secondary. The Guardians and Wards Act section 25 already says this very clearly. It says the title of the guardian, if a ward leaves or is removed from the custody of a guardian of his person, the court may make an order for his return, and for the purpose of enforcing the order may cause the ward to be delivered into the custody of the guardian. So the Guardians and Wards Act already has text in it which denounces such wrongful removal and retention.
That would be my very first objection, and that runs through the bill. So there are many other very objectionable parts.
I'd like to add to this point that where the child should be throughout the bill hinges merely on what's called its habitual residence. And this completely ignores that for a child, place of residence is a technicality. What matters is who is the primary caregiver, to whom is it attached. I mean, so long as it's with a loved parent, it doesn't really care where it is.
Well, Ms. Iyer brings up a very important point about habitual resident concept. So she argues that habitual resident requirement is mere technicality, and that what is most important is that the child is with the loving parents. So this gets confusing. So this is exactly what the Hague Convention provides, that it's when a child is abruptly removed from the care of a parent, that it be brought back to the care of the loving parent. So it's really confusing that while Ms. Iyer says that the child, the most important thing for a child is to be with the loving parents, at the same time she says Hague is not good because Hague is requiring exactly that.
And I think that it's cruelty to the child have this cold-blooded bureaucratic decision on habitual residents to decide. I mean, when the child is with parents abroad, it may be habitually resident there, but that's irrelevant to its best interest or its happiness or security.
Here is where Miss Iyer's arguments get very confusing, and probably it is her intention to confuse the people. Let's say she keeps attacking this concept called habitual residence. Just to point out that under Section 9 of India's Guardians and Wards Act, the words "where the minor ordinarily resides" is used. This is the same thing as habitual residence, just a different use of words. That's all. The concept is the same. That is, where the child has been ordinarily residing with both the parents. So she argues that what is important is that the child have the love of both the parents. Yet she is against the very bureaucratic measures that Hague brings in that will ensure exactly that. That is, Hague ensures that the child cannot be abused by abruptly removing it and retaining it in some other place, removing it from the love and care of one parent and then taking it to another place. And Hague provides for immediate return to status quo so that the child is unharmed. So the Hague process is what is preventing the child abuse. Yet Ms. Iyer keeps insisting that the love of both parents are important, yet she does not want Hague to help attain that.
Yeah. So I think she's made a very important, relevant point. I'd like to add to that, Indian law doesn't even have a definition of habitual residence. And for the first time, that definition is being smuggled over here.
Well, here again, Ms. Jaising is needlessly stressing on the semantics and the use of words. She tries to confuse people that the word habitual residence is being smuggled into India and there is no such thing according to Indian laws. Well, she is a lawyer. She should be aware of India's Guardians and Wards Act, where it clearly uses the term ordinarily resides. I'm just it's kind of silly for a lawyer of such a seniority to try to confuse people with stressing on small differences in the choice of words by two legislations or two texts that were created decades apart. So as far as the part about smuggling, let me remind to the viewers that India's Guardians and Ward Act, which mentions ordinary resides, was enacted in 1890. And the Hague Convention on the Civil Aspects of International Child Abduction came into force in 1980. That is, the Hague Convention was the text of Hague Convention was firmly established 90 years after the India's Guardians and Wards Act. So, Ms. Jaising, who is exactly smuggling from whom here?
We don't even know what is the difference between habitual residence and ordinary residence. Now, just to give you an example, if the a mother was an Indian citizen, she could argue that I have been ordinarily resident in India. For the purpose of marriage and for a brief period, I might have gone abroad and that might make me quote unquote habitually resident overseas. But actually, I was born, brought up in India, married in India, and very often even a citizen of India.
So, Ms. Jaising is a senior advocate. Ms. Iyer is a lawyer. I am not. Law is not my career, profession, or my passion. None of those. Yet, Ms. Jaising conveniently tries to bring in the habitual residency or any residency aspects of the parent or the mother here. Why is that? We are not concerned, the Hague is not concerned about the habitual residency of the parents at all. Hague is about the children, and Hague is talking about habitual residency of the child, nothing else. But Ms. Jaising here tries to dilute that and mislead the people, bringing in the domicile residency aspects of the parent, which we are not concerned about here. So, Ms. Jaising, what is your intention in trying to mislead people? Did you not read the text of Hague well enough to make such misjudged statements when future of children is being discussed here?
And yet you give habitual residence, as she says, priority over. So that brings you to the question, what should be the critical priority for deciding whether a child should be sent back or not? I would say never send a child back unless the child personally wants to go back. That's a different issue altogether.
So, Ms. Jaising continues to confuse people even more. Ms. Iyer herself said that what is the most important thing for the child is the love and care of both parents, irrespective of where it is. That's fine. But Ms. Jaising goes ahead to say that she questions what is the critical factor for sending the child back. When Ms. Iyer herself has answered that that very same question, and she makes a blanket statement that child should not be sent back at all. So seems like Ms. Iyer and Ms. Jaising are in disagreement here. While Ms. Iyer is recommending that the child is best taken care of in the care of both parents, Ms. Jaising does not want that. She wants the child to be brought up fatherless or motherless, and perhaps this is the kind of society that she is forcing India to embrace in future. It's kind of disturbing to hear that coming from such senior advocates, because there are a lot of families that goes through this divorce and separation and stuff like that, and find a civil way to sit across each other and figure out a child custody arrangement which benefits the parents as well as the child and children. But Ms. Jaising does not want that.
But it has to be one principle and one principle alone, and that is the best interest and the welfare of the child. And you cannot, it's also about taking away all agency from children. I mean, I've seen cases where, children are clinging on to their mothers and crying and weeping and saying, don't separate us from you. And yet, there will be the court order, there will be the bailiff, there will be the policeman who will be coming and literally tearing the child apart from the mother's breast and saying, sorry, there's a court order, you have to go. So the issue is, what are you going to, she said, Suranya said, please don't base this whole law on habitual residence. And the question, of course, will be, base it on what?
So, and this comes to another very important point, which is that under Section 3 of the bill, even an institution or other body in the foreign country can apply for the return of the child. So, this means that we are not just dealing with interparental claims, but we are giving orphanages and child protection agencies in foreign countries higher rights of custody to the Indian child and its own family. And this runs foul of a host of laws which has a whole history of agitation and lobbying among the women's groups in India. After many years, we managed to get laws where the divorce cases and other things could be filed where the wife was resident. You didn't have to go by the habitual residence of the husband or where they lived when they were together as a matrimonial couple. And the reason was that this habitual residence is an irrelevant technicality in these matters.
If I may say so, the reason was not just a habitual technicality, but the reality of the situation, that the habitual residence of the woman and the man can be different. And then how do you decide the habitual residence of the child? And the law.
So Ms. Jai Singh and Ms. Iyer again bring in the concept of habitual residence into the argument again. This has been said before. What matters is the habitual residence of the child. That's the place where the child was living with both parents, and all of a sudden one parent decided to flee the country with the child. That original place of residence is the habitual residence for the child. We don't understand for such well-read lawyers what is such a difficult thing to understand here.
She was referring to was the Domestic Violence Act, where that brings me to the whole question of why do women in the first place pick up their children and run from a foreign jurisdiction back to the country of their origin? The reasons are they face domestic violence at the hands of their husband. I mean, after all, a woman who gets married to a so-called NRI with so much pomp and show and having spent so much money, she would have a vested interest in living with her husband. The point is, very often these women are actually thrown out in situations of domestic violence. At that point, they pick up their children and they get back to the country. You must understand that these women don't have a green card, they don't have a visa, they're dependent on their husbands for the right of residence in a foreign country. Now, if you expect such a woman to leave a child who may be 6 months old, maybe 1 year old, maybe 2 years old, it doesn't matter what age, but to leave the child behind and go out of the country because she's kicked out, that is expecting the impossible. This is the reason why they pick up their children and come to India.
Now here Ms. Jai Singh touches upon other new arguments like domestic violence and all that some kind of stuff, and she argues why women should leave everything and come to India with a child. She talks about how women have lofty dreams when they get married and stuff like that. Well, that is the same situation with partners that don't abduct their children. Also, they also go to foreign countries and get married to NRIs. Have differences with their spouses, and then they split legally, file for child custody legally, and make sure the children are taken care of. Why is that only a select few resort to this illegal activity? That's the question that everyone needs to ask, and everyone needs to figure out the facts behind the situation rather than just throw a blanket statement at those being the only reasons why women flee. One of the reasons why women flee is because India is a safe haven for such people. India gives them the protection. Why would India give them a protection is the question here. Why would India a country that respects a civil society, where the country has framed so many laws, so people follow those laws, and there is order in the society, why would such a country encourage people to go to other foreign countries, receive all the benefits of those countries, and then say that they are not obliged to follow the laws of that particular country? Would India be okay if a foreign citizen comes to India and commits a crime as per Indian laws and flee the country, flee India, and claim that these laws are not applicable to them? Lawyers like Ms. Jaising and Ms. Iyer should be ashamed that they are supporting and encouraging such breaking of laws by Indians. It brings a bad name to India. Instead of encouraging unlawful behavior by Indians in other countries, Ms. Jaising and Ms. Iyer, as lawyers in the profession of upholding the rule of law in any country, should be encouraging women and men, or whoever it is that goes abroad, to respect the laws of the land, to understand the laws of the land, and to religiously follow the laws of the land. If they do not agree, then they should not be going to those countries. People cannot go to another country and then pick and choose what laws they want to follow. This is how the civil society is built. They should also be encouraging women to contact the law enforcement agencies, contact the Indian embassy in those countries, and avail of all the resources available to fight any domestic violence allegations or whatever that is there. Here we are talking about this phenomena mostly happening for abductions from some of the most developed countries like USA and UK, where there are very strong protections for women or men or any sorts of domestic abuse victims. Law enforcement is available within seconds of someone calling 911 in the USA. And some of the people that have fled the country, from my own case, are well-educated people having jobs in this country. And for Ms. Jaising and Ms. Iyer to go on condoning their activities as very valid, this is a very wrong stance to take. And also, what about all the men that have fled the country with the children and leaving the mothers here fighting for the child? What kind of excuse do Ms. Jaising and Ms. Iyer have for those people?
I would just like to add to that there's also another kind of prejudice and power dynamic at play, imbalance at play over here, which is that in general, an American court and Americans, even till today, they probably couldn't point India out on the map. And there is a pervasive idea that India is a complete dump and it would be much better for a child to be in America than here under any circumstances.
Well, so here Ms. Iyer, in her usual tone, indulges in sensationalism, as I call it. She says most people could not pinpoint India on the map. That might be true, but we cannot ignore the fact that um, Americans also are the ones who have embraced Indian culture and values, like, for example, yoga. In American schools have started teaching yoga long before even Mr. Modi's government started talking about yoga. So please do not indulge in such kind of sensationalism in such an important matter, with which concerns a child's rights to being raised and loved by both parents. Nothing is more important than that, Miss Iyer. Please stay on the topic of a child's best interest than indulging in unwanted aspects.
So it's not just a question of husbands versus wives, but you're facing an attitude that is highly prejudicial against allowing Indian parents access to their own children. And this is the reason why courts in America are often completely unsympathetic to the Indian parent claiming custody of the child in India, only because they feel, well, why would we send any child to India? To give you an example, when Indian children are taken in the US by their US child protection agencies, and we say that while the parents are fighting the abuse allegations in court, and more often than not they are winning them and proving their innocence, let the child come back to its relatives in India. The US system, through International Social Services, does a home study of the relatives in India, where the questions are: what are the air conditioning facilities in the home? What is the physical appearance of the relative? I mean, these are this is not the way in which
Suranya,
these are.
I can ask you, would you say that the attitude is almost racist?
The attitude is racist. I mean, what is this other than racism?
Well, here Miss Iyer and Miss Jaising throw another sensational word, racism, racist. Not surprising. So let's see. So they're accusing the agencies of trying to see how good of environment is for the child in India to stay with relatives while the couples are fighting abuse allegations. That's fine. So what exactly is wrong with say, for example, she mentioned checking if air conditioning facilities are available in the place. What exactly is wrong with that? The climatic conditions of India and USA are not the same. In lots of parts of USA, it snows. And children are accustomed to that kind of climate. And it is difficult for children, especially young ones, to adjust to a drastically different climatic conditions. So they naturally, a lot of kids, and including adults, when we travel to India, we find it very difficult to adjust, because we have been acclimatized to the weather and climate patterns here. And the courts and the agencies, as you can see from the very example that Ms. Iyer provided, are very much concerned about the well-being of the child. If the child can have discomfort, the first security for the child is always the parents with which it has been raised. And if the child is being now sent to stay with relatives and does not have access to the parents on a regular basis, what do you think is the best interest of the child? Miss Iyer, are you really saying that the distance between the child and parent should be even more? We don't get your arguments, Miss Iyer. I don't think you are looking at the best interest of the child. Rather, you are looking it in a very narrow-minded way, you somehow feel very inferior when you need not be. The courts here are very sympathetic to the needs of the child, and they make sure that that happens.
And I'm very sorry to say that we often find that that it's the women in these privileged countries who take up the cause against mothers in third world countries. I don't see this as a woman-friendly approach at all, given the statistic that you pointed out in your article.
So, what is very important to point out is, this law, proposed law, gives the appearance that it is gender neutral, okay? Because it says a bill may be called Civil Aspects of International Child Abduction Bill 2016. So an argument could be, well, if a woman picks up her child and comes away, so could a man pick up the child and go away, and then an Indian woman will have access to this bill to get her child back. The fact of the matter is, statistics worldwide indicate that more than 60% of all cases of so-called child abduction have been brought against women. So it's obvious that these laws, though facially gender neutral, actually have a very disparate impact on women. And so you come back again and again and again to the same issue. Why is there no recognition of the phenomenon of domestic violence in this country? I asked that question.
Because our civil procedure code already provides for the recognition and enforcement of foreign judgments and foreign laws where they are applicable in India. Alright? So there was really no reason to have this act at all. And what this bill does is that it actually allows claimants, this is under section 3 of the law, of the bill, to claim a right of custody by operation of law. So you don't even need a court's judgment. You can just make a claim that under the laws of my domicile, I have the right to the custody. And at that point, when you go to the High Court, section 19 of the bill says that the High Court can rely on this claim of the law by an individual, not even a lawyer, without recourse to the procedures for proof of that law. So this means that the bill empowers the High Court to send the child to a foreign country based merely on the applicant's claim that he has custody and his further claim that this is the law in his country of domicile.
Correct.
It makes no sense.
So what this law actually does is it bypasses India's judicial system, as if India didn't have a judiciary at all, and it hands over the judicial function to a bureaucrat who all he needs to do is to look whether a foreign court has given an order. 99% of the time it's an ex parte order where the woman has never been represented. The order has been passed after she left the country. She's had no access to legal services or money for payment of fees. And this bill actually says that if there is a court order, you blindly send the child back. Now, in contrast, the Indian Supreme Court has, as recently as in the month of September 2017, I would say August, taken a decision which is a very, very, I would say, proper and correct and legal decision, where they said that, I quote, "We hold that the custody of a minor with the appellant, that is the mother, being her biological mother, will have to be presumed to be lawful." Whereas this bill says that custody is unlawful if there is a court order, even though it's ex parte in her favor.
So Ms. Jai Singh goes on to say that the whole Hague process bypasses the Indian judiciary. That's a very interesting point coming from a lawyer. What it actually does is it is basically Committee of Courts, Indian judicial system respects the fact that the child has been abruptly removed from the other place, and even according to Guardians and Wards Act, that is section 9 in the Guardians and Wards Act, it specifically says this: if an application with respect to the guardianship of the property of a minor is made to a district court, other than that having jurisdiction in the place where the minor ordinarily resides, the court may return the application. So basically, here by sending the child back, by ordering the return of the child back, the courts are basically following what the Guardians and Wards Act in fact provides for. That is to send the jurisdiction back to the place where the minor ordinarily resides. That is where it was uprooted from. So it seems like Miss Jaising is tiptoeing around all these Indian laws to her convenience, and is trying to make it look as if something has been forced upon the Indian judicial system.
Secondly, the Supreme Court has unambiguously said, and this was a case of inter-country marriage. It was a case where the woman left UK and came to India with the child. It was a case where the child had also taken up citizenship of the UK. In spite of all that, the court came to the conclusion, no, we are going to look at what is in the best interest of the child. And they came to the conclusion that it was in the best interest of the child to remain with the mother in India in the face of a court order granting an ex parte order to the father. They disregarded that. They said comity between courts is not the deciding principle. The deciding principle is the welfare of the child. Now, in the face of a judgment of this kind, I really fail to understand, well, either the draftsperson of this law have not read judgments of the Supreme Court, or, as you say, there is some political agenda.
So the Indian bill on the international parental abduction is broadly in conformity with the Hague Convention. So you think that the government has already decided to sign the convention and despite the resistance from the women in the child group?
It's clear to me from the fact that they're holding a consultation, which is tomorrow and day after. And it's also clear from the fact that if you read it, it says, whereas India is a party to the Hague Convention, and the entire convention is annexed to this annexure. So the whole idea is to simultaneously sign the convention and to get this law passed. Now, you know, I think it's unfortunate that the Indian women's groups have, for reasons which are too difficult to clarify right now, been unable to present their case in a very systematic manner before the government. I have been receiving email after email from women who are in situations where they've had to flee with their children since the announcement of this meeting was made. And I just hope that they organize themselves either to do a Skype conference with for the consultation tomorrow and day after, or that they come personally to tell their story, their point of view. What I do think has happened is that the groups of lawyers representing NRI men who are very well funded have succeeded in lobbying with the government for the signing of this convention. I don't think that there has been adequate debate and discussion on it. I don't think judgments of the Supreme Court have been looked into. I don't think that the drafters of this bill understand that Indian courts have parens patriae jurisdiction over all children found physically within the territory of India. Even if it's a foreign child that you find abandoned. You know, one of the very first cases which ever went to court, it wasn't on the case of child abduction, but this whole jurisprudence of parens patriae was developed. And if a slave is found in a foreign country, that slave will also be given due process of law and justice. Okay, because it's the courts which then step into the picture and become the parents of the child. So to now turn around and say that the parens patriae jurisdiction of the court will be taken away, and it will be some bureaucrat sitting in Shastri Bhavan who will decide whether the child is to be returned, I think it's a sorry day for the country.
Mrs. Jaising brings up another interesting word, parens patriae. In ratifying Hague is actually enforcing that very principle. Parens patriae means the courts, wherever they are, whether in India or USA or UK, they take the best interest of the child considerations upon themselves and work towards that. So when India ratifies Hague, what India will be doing is that the Indian courts that will process the Hague applications will look at the merits of the case, and if the merits of the case so justify, they will act as parens patriae and say that it is the foreign court's jurisdiction that will have the best interest of the child in mind, are the most competent with the information available regarding the child's welfare, and hence the child has to be returned back to that jurisdiction. That is all the Indian courts will be doing. That is the same thing even the foreign courts will be doing. Absence a custody order, there is no custody decisions that is made during the Hague process. Hague process does not decide custody. Hague process only ensures that the child is returned back to where it came from, so that the courts in that place that have the knowledge about the child's welfare as it was residing there decide what is the best custody arrangement for the child. So it's basically both the courts in India as well as the courts in other countries acting as parens patriae in this case.
And for the judiciary.
Yeah, and I would just like to add that forcibly deporting a child based on a claim of habitual residence is basically enslaving the child. And I mean, I think that we have a lot of things that we need to legislate about and to develop policy on, and that I cannot understand why so much energy has gone into sending children away from India. It makes no sense to me. But let us not forget that the United States, which I believe is behind this move, has itself not signed up to the Convention on Child Rights.
So that's a good point, Ms. Iyer. Yes, US is not a signatory to the UNCRC, very valid. However, it is to be noted that USA is the one who has drafted majority of the UNCRC and has adopted the same in its domestic laws. The Uniform Child Custody and Jurisdiction Enforcement Act that has been adopted by all 50 states of the USA are based on the same principles as UNCRC, and it guarantees equal rights, equal parenting rights, and even though US may not be a signatory, it has implemented all the aspects of the children's rights in its local domestic laws, and that's all that matters. However, India has ratified UNCRC and is in violation of so many of the articles that UNCRC demands, especially with respect to a child having both parents in its life. It's considered one of the fundamental aspects. So, what is better, Ms. Iyer? We don't know. Is it better to ratify UNCRC and violate those, or is it better to is it okay to not ratify UNCRC yet adopt all the provisions that UNCRC requires?
So the United States is very wise to the need to preserve a certain amount of sovereignty over family affairs, and I think that they should show the same understanding to us and to children.
I would just like to give one example of a case to which I was personally witness. And this is a case of a woman who fought this kind of a battle and she lost it. And let me tell you, I mean, look at this law. This is basically a child policing law. It's got a provision in it which says you can take the services of the police. And it gives powers to the bureaucrats to summon, to get documents, to arrest the child. Okay, so this was a very tragic case where she fought a similar battle.
Here again, Ms. Jaising tries to sensationalize things, trying to make it appear that foreign courts are evil, Indian laws and courts are very look at the child's interest in a different way. She talks about the wording about the child being arrested due to the application of this new bill. Let me remind Ms. Jaising of India's currently existing Guardians and Wards Act. Section 25, as you can see, specifically says this: if a ward leaves or is removed from the custody of a guardian of his person, the court may make an order for his return, and for the purpose of enforcing the order may cause the ward to be arrested and to be delivered into the custody of the guardian. This is existing India's laws. So how is that Ms. Jaising accuses the foreign courts to be very abusive about this, and when India's laws also have been requiring that since 1890? Does she have an explanation for that?
And she lost it in the Supreme Court. The Supreme Court has sometimes been very, very heartless with women who have brought their children to India, and they passed this order. You know, to my knowledge, this woman went underground with her child to avoid the writ of the court, and she was never found by anybody. So we don't know where she went away with her child. We don't know what happened to her. This is one example. And there was another very tragic example of a woman. And this woman was working, I do not want to give you the name of the organization, it will identify her, but she was working with an international organization in the United States of America. And her husband came here, and he asked, her husband filed a petition here for the return of the child to the country. And the Indian Supreme Court asked her, the mother's mother, to stand surety for the child, and impounded the passport of her mother for 5 long years. And her mother could not travel because this woman took a decision: I'm not going to comply with the order of the court. Now, I can't say whether she was right or wrong in doing it, but I'm pointing to the tragic consequences of passing orders which are completely heartless and which don't have any basis in reality.
Considering all the aspects that the women do not have support in foreign land and they come back, and it can be a case of domestic violence or other tragic incidents, and they come, the child is removed from the so-called habitual residence. What do you think is the way forward? Like, this issue will by not signing, if you're suggesting that India should not sign the convention, what should India do in the next step to address this issue?
The way forward has been indicated by the Supreme Court of India. We have well-established courts in this country. Our courts will continue to have parents patria jurisdiction over children found within their jurisdiction, and the father and the mother can both work out their rights in a civilized manner.
Thank you for tuning in to NewsClick. I'm Shivangi Mishra from Lawyers Collective.
So in closing, this is all I have to say about this. Miss Jai Singh and Miss Iyer, they are both lawyers. They make a living out of representing people that run into these kind of issues. It is in their interest that this issue stay alive, so that they are, they are being approached for fighting these kind of cases. Second thing is, we need to see that Ms. Jaising and Ms. Iyer go where the money goes. So few years ago, Ms. Jaising took the stand that parental child abduction is an issue that has to be handled, and that ratifying Hague is the right thing to do. But today she speaks differently, and who knows what she's gonna speak tomorrow. So as you can see, they don't really have the best interest of the child in mind. In all this conversation that we saw, they are not talking about the best interest of the child. They are talking about nationalistic sentiments. They are putting down the courts and systems in developed countries that India itself tries to replicate in India. They try to sensationalize things by using selective terms, while us, the parents that have lived through this every single day of our lives since our children have been abducted, know what the problem is. We are just we want our children back to where they were abducted from. We want to sit across the tables with our spouses and come to an agreement, but we will do it in a very civil manner. We don't want to follow any criminal procedures and make an already volatile situation even more dangerous. We want to spend our energy on raising our children. We do not want extended litigation for years together, which is typical in India. But extended litigation and protracted legal proceedings is exactly what is in Ms. Jasing's and Ms. Iyer's interests, because that fits their bottom line. So while we are here trying to be involved in our children's lives, Ms. Jasing, Ms. Iyer and her likes are needlessly intervening in this very crucial issue. They have only information from only one side, yet they judge the other party. They go bashing NRI men, and they seem to be sympathetic towards women, but in reality they are sympathetic only to the women that fled to India, not the women who lost their children in the foreign countries, who are fighting to get the children back. So these are all the double standards that you can see in this video presentation that they have put out. We find that it is our responsibility to keep the general public aware of such misinformation, and since these matters concern children that themselves cannot fight for their rights, it is our parents' duty and responsibility to rebut all these false allegations and misinformation, and speak about the ground facts. We already see that in current existing Indian laws are already in line with the with those that Hague calls for. So it is just a matter of clarifying that clearly in the Indian laws to apply to international context. That's all that Hague requires as a change in Indian laws. Nothing more. Thank you.